Okay, can you hear me? So, dear colleagues, fellow students, ladies and gentlemen, my name is Forst, and it is my great pleasure, honor, and privilege to welcome you all on behalf of Normative Orders, together with my dear colleague Nicole Deitloff, who sends her regards, and Klaus Günther, who is somewhere in the room. I welcome you to a very special event tonight, and it is special in a number of ways. All of them due to the two great colleagues who will speak after me, Professor Seyla Benhabib and Professor Ayelet Shachar. If you had asked me some time ago what ideally I would wish for as regards our Normative Orders Center here, I would have said that it should be the home of innovative and cutting-edge research projects on the pressing issues of our time. And I think what we have achieved with projects like Contrast, supported by the state of Hessen and the National Institute for the Study of Social Cohesion, is going in that direction. But it would have been almost too utopian to think of something like the event tonight, the launch of Ayelet Shachar's Leibniz Award project on transformations of citizenship as part of our Center Normative Orders, collaborating with the initiatives I mentioned. Ayelet is part of Contrast, and with the Monk School, the Harney program at the University of Toronto, and the Max Planck Society. This is a realized utopia, and I want to thank you from the heart, dear Ayelet, for this wonderful cooperation, and you, Seyla, for not just coming over as a fellow of the new program and Normative Orders these weeks, and for delivering this keynote, but also for organizing such an impressive conference on borders, territory, and rights, together with Ayelet, that brings such a great number of world-renowned scholars to our campus. We're here tonight, and whom I also welcome enthusiastically. Great to have you here. Before I say a few more words about Professor Shachar, who will introduce Professor Benhabib and say something about her own program and plans, so there's a list, quite a bit of introductions going on here, but I'll be brief, I promise. I just want to insert a personal word to and about Seyla. She is, simply put, one of the great political and social philosophers and critical theorists of our time, from whom we all learned and learn a great deal. And the way in which she extends her theoretical reflections on the dynamics and contradictions of our present times to an in-depth analysis of the legal frameworks in which we think about and deal with refugees especially, is exemplary for empirically grounded and morally principled critical theory. And last week we had a conference where we talked about some of these issues. But rather than going on endlessly, as I could, to praise Seyla's work, I want to use the opportunity to say a personal word of thanks, not just for over 30 years of friendship, which I enjoy very much, but also, dear Seyla, for your support of Normative Orders as a member of our advisory board ever since it came about, almost 15 years ago, and especially for your solidarity and unfailing support and engagement in times of crisis. It is a truism that friendship is proven in such moment, but how true it is, you only find out when you need it. And so, dear Seyla, in the name of all here in this enterprise we're having, we thank you from the heart for being with us throughout the years in such an active and supportive role. Professor Shachar, another dear and longtime friend, is one of the major, as you know, legal and political theorists working on issues such as multicultural societies with a special focus on women's rights. If you think of her great book, an award-winning book, Multicultural Jurisdictions. On questions of citizenship in the light of global principles of justice, think of the Birthright Lottery, also an award-winning wonderful book. And she works, of course, on migration and the meaning and relevance of borders and passports, and discusses this in her recent The Shifting Border, also with a company of critics she responds to masterfully. Lots of other publications would have to be mentioned, such as the great Oxford Handbook of Citizenship. She co-edited, but I promised to be brief, and so it'll just be said that among those who think through the inequalities of our time having to do with the way our societies change internally and externally, if that is the right distinction, and we'll discuss how closely connected internal and external issues here are, how they organize their borders among the great group of people who work on this. Her work truly stands out. Ayelet has crossed a few borders herself in her career. Having studied in Tel Aviv, she received her LLM and JST at Yale before accepting a professorship in law and political science at the University of Toronto. In Toronto, she also held the prestigious Canada Research Chair in Citizenship and Multiculturalism. In 2015, she made a huge step over the Atlantic to accept the position of director of the Max Planck Institute for the Study of Religious and Ethnic Diversity in Göttingen. And from the start, we happily cooperated in the so-called Goethe-Göttingen exchanges, as we called them, between Normative Orders and her fine institute, and had a number of great conferences. Ayelet has received numerous awards and recognitions for her work, and it was much to our delight, but also no surprise, that the German Research Foundation awarded her the most important distinction for research in Germany, the Leibniz Award, in 2019. At the same time, she became and still is professor of law here in Frankfurt, and when she decided to relocate her main academic activities back to the University of Toronto, where she's today professor of law, political science, and global affairs, more specifically the Harney Chair and Director of the Ethnic Immigration and Pluralism Studies program at the Monk School of Global Affairs and Public Policy. When this happened, we were thrilled that she also decided to place her Leibniz Award research group. The Leibniz Award comes with quite a bit of research money. I won't mention the sum here, but it is a decent amount. We were thrilled that she decided to place her research group with such great members as Eva Maria Scheffele and Benjamin Boudou here at our center. And this inaugural event is the official start of this collaboration. And as I said, to have Seyla Benhabib present the keynote and such a great international conference with superb experts on migration and mobility to follow up is close to what good old Leibniz would have called the best of all possible worlds. So thanks, Ayelet, for creating this world. Thanks to you all for populating it, and the floor is yours.
Good afternoon, everyone. Welcome to all our guests from abroad. Welcome to so many friends and colleagues and interlocutors, and of course to my friend and colleague Rainer Forst. This was absolutely over the top, so don't believe half of it or even a quarter of it would be like a nice flattering image, but I am so really thrilled to be here with you and to share this special moment that we're starting a new research group, as you can see, entitled Transformations of Citizenship. We love the logo, so in addition to our intellectual work, we also care about aesthetics. And really, for me, having the opportunity to have this research group here at Normative Order indeed is a dream come true. It fits very nicely with the long-term collaboration that Rainer and I have had when I was serving as director for the Max Planck Society. Also quite delighted to see a few people from the Max Planck Law Network that I worked with in the past. So nice to have you here with us to continue this conversation. Rainer introduced me, and I'm going to introduce Seyla, but I have to say a few words also about your brilliance, or maybe I can save that. You all know Professor Rainer Forst in this room, and the extraordinary work that he has done himself, and of course with Normative Orders. I also really want to thank Professor Klaus Günther, who is here. He really helped facilitate my arrival to Frankfurt as a professor here at the Faculty of Law, and I'm really thrilled to be involved with Normative Orders First and Law, and again, to welcome all of you. Now, of course, we are here to celebrate the public lecture that Professor Seyla Benhabib will deliver. But before I do that, for the North Americans, at least in the room, I hope you find it extraordinary that we're in the Normative House building, Normative Orders House, and we are on Max Horkheimerstraße. Like, if this is real, there's an Adorno-Platz here. So for those who are here for the first time, the Frankfurt School lives on here. I find that just to be in some way connected to that legacy is extraordinary. And of course, Normative Orders has brought this back to life or continued it. And again, this is why for me, this is such a special moment. And I'll just say, two additional personal things. First of all, the first time I met Rainer Forst was actually at a conference, Seyla, that you organized, that Professor Benhabib organized at Harvard. At the time, we were all thinking about toleration, diversity, accommodation, and that was really our first time, the three of us together. This was a while back, maybe 20 years ago. So for those of you who are here, for the junior people, maybe 20 years from now, you'll continue the tradition. We very much hope that some of you will stand on the shoulder of giants and do the hard work, and hopefully you'll have a research group or you'll do your work and continue to push all the hard questions that we really need to address. And there's no chance in the world that even in our very intensive workshop that we have for the next 2 days, we'll only scratch the surface. So really an invitation for those of you who are on the junior side. Hang in there, it can be tough, but if you make it, it's really, really worth it. So in terms of the other personal thing that I want to say, I am an academic scholar. I do legal theory, and I also dab into political theory, and I really, really like the combination, and I also like to think about institutional design, so not just a very abstract level, but also working from the ground up and trying to find potentially new alternatives for the real difficult issues that the group deals with, which is citizenship, diversity, mobility, democratic inclusion, inequality or immobility, and global inequality. So all of these issues in my mind are intertwined and require this interdisciplinary perspective. But if I had another life, I probably would have been an architect. And why do I mention this to you now? What do architects do? What's the part that I like about architecture? You have a crazy idea in your mind. Then you have to do a sketch. Then hopefully you have some great, amazing colleagues, such as the people that we have here, and especially, as I said, the people who traveled long and far to be here with us. Hopefully, as I said, you can interact, refine, redesign, do a lot of hard work. And then if you're lucky, someone sponsors your project, as we were lucky. And then you get to actually, hopefully, create a beautiful new structure. And then it impacts the location in which it stands and the people who enter through it and work there and interact with others, hopefully have some kind of special ambient if you're successful enough, if you are a good enough architect. So, to give you an example of what I'm thinking of very ambitiously, I mean, think about the British Library, think about the Taj Mahal, think about the city of Petra in Jordan, what remains of it, the great mosques of Istanbul. And because Professor Benhabib is here, I myself grew up in Jerusalem. The old city of Jerusalem is uncomparable to anything. This is how it was very easy for me to think about multicultural jurisdictions. I lived it, so I know it, and it probably is also not only temporal, but not only diachronic, but also comparative, and in Jerusalem it's also architectural. So there's so many different dimensions of existence. So of course we cannot reach those levels, but I do believe that some of the work that Normative Orders did, and this is why I mentioned architecture, this is a real structure where amazing ideas have been created, and I hope that our partnership now will lead hopefully to even new and greater ideas. And I'm excited about the combination of bringing in legal scholars and political philosophers to really think about some of the most pressing issues of our time. So the germ of this particular workshop, so we have the lecture, and then we'll have a workshop for the next 2 days. I have to tell you how that came about. This is actually really Professor Benhabib is the force behind it. And you remember we spoke about a year ago. Professor Benhabib published a fantastic article, which you probably have read, about the end of the 1951 Refugee Convention, raising a lot of serious concerns. And this was very recently after I published The Shifting Border. And we were just struck because we were stumbling on the same hard questions, what to do with territory and territoriality and extraterritoriality, and how it impacts rights, actually impacting rights in a negative way, denying access to protection, especially for asylum seekers, but also to a more general audience of, or more general group of migrants and potentially citizens as well. So what we thought is that we would bring some of the best minds, so all of you who are here with us for the remainder of the conference, very senior, very junior, different disciplines. That was our vision. And we really hope that we will be able to identify some ways or ideas about how to prevent or at least mitigate the erosion of rights protections, and also hopefully to find creative ways to democratize shifting borders. So that's the very ambitious intellectual agenda that we have set for ourselves. And we're looking at the combination of institutional and democratic possibilities and really looking for routes for resistance, claims making in a world of shifting borders, and also thinking about, this is again Benhabib's work, about a cosmopolitanism without illusion. So again, this is the high benchmark that we will try to achieve. And I also just want to acknowledge that this public lecture is also the beginning of another collaboration between Max Planck Law, the network, and Toronto and Frankfurt. So it's really, really wonderful to have people here from that network, again, continuing some of my older connections with Max Planck. So now, after I've given you all this background, we're going to turn to Professor Benhabib, and I'm going to introduce you. I can't do justice, exactly. Seyla asked me to be brief because otherwise you would have to sit here for 15 minutes, if not 30 minutes. So I'll try and just provide some of the highlights. And again, if someone needs no introduction in Frankfurt, it is Seyla Benhabib. So as you all know, Seyla is the Eugene Meyer Professor of Political Science and Philosophy Emerita at Yale University. She has been there from 2001 until 2020. And I was just struck that it was such a long period of time, extraordinary. She's currently a senior research fellow at Columbia University. We also have Michael Doyle joining us from Columbia, so thanks for making the trip. Very thrilled that you are here. And at Columbia, Professor Benhabib teaches at the law school, and she's also an affiliate faculty in the Department of Philosophy and a senior fellow at Columbia University's center, which has the longest name, Center for Contemporary Critical Thought. Okay, even their abbreviation is long, so I hope I didn't miss anything in that title. But just to show you, again, fitting very nicely with our idea here of interdisciplinarity, that's so, in a way, so organic and really fits into, I think, the only way to think about these difficult issues that we are going to address. Now, she has so many distinctions that I'll only mention a few. Professor Benhabib is a member of the American Academy of Arts and Sciences. She's also an honorary fellow of the British Academy, and I believe Professor Forst too is in that very distinguished position. So we are in very, very good company here, as you can see. She has received numerous awards and prizes. I'll just name a few. The recipient of the Bloch Prize, the Leopard Lucas Prize, and I'm hoping I'm pronouncing this right, the Meister Eckhart Prize, roughly right. So all of these. The Eckhart? Meister Eckhart. Eckhart. All right, somewhere in the vicinity, not bad. All right. She's also the holder of, she also received several honorary degrees. I'm not going to list all the universities. And I think to me, perhaps her most lasting influence, as many again in the room will know, is just her fantastic writing. It's not only prolific, it's always deep, it's creative, it takes you on a journey that sort of Seyla holds your hand, and she doesn't give you compromises. Sometimes it's really, really difficult to work through the materials, but they are so important. And I think for many of us, Seyla, you're really a guiding light, how to push oneself, how to bring in the most creative work, how to never compromise, how to always deal with new challenges and ideas, and working very, very abstractly, but also very, very concretely. We spoke about this, the moving between the different levels of analysis, I think is really unique and hopefully fits also with what normative orders is committed to in terms of the empirical and the normative. So we are really glad to be part of that. And just going back to my image of architecture, so if we can enter something that's not physical, but some kind of an imagined temple of knowledge, let us do that. And I think Professor Benhabib's lecture will do this for us in a minute. I'm just going to mention a few names, and then we'll turn to our main event, which is the public lecture. So Professor Benhabib, as again many in the room would know and have read her books, I'm just going to mention a few: The Claims of Culture, Equality and Diversity in the Global Era. So this actually comes out from that period that I mentioned earlier, that the three of us met in that conference at Harvard. The Rights of Others, Aliens, Citizens, and Residents, again needs no introduction in this audience. another cosmopolitanism, hospitality, sovereignty, and democratic iterations. Again, this idea of democratic iterations, which comes back, and we might even hear a little bit about it in the lecture today. And most recently, exile, statelessness, and migration, playing chess with history from Hannah Arendt to Isaiah Berlin. So again, very fitting to be here at this university and to discuss this playing chess with history again, given the depth of history here. And Professor Benhabib's lecture is entitled The Crisis of International Law and its implication for the Refugee Convention. And this new work is based on a series of lectures that Seyla delivered at the University of Milan earlier this year. And most importantly, it's part of a new book entitled The New Sovereignism, A Democratic Critique. So without further ado, I hope you'll join me in welcoming Professor Benhabib, and we'll have a Q&A session later on, and we're asking if you can wear the masks, just given that the pandemic, unfortunately, is not fully over. So thank you so much. Again, a warm welcome.
I don't know what to say. I'm at a loss for words. Thank you both so much for these kind words. Above all, as many of you know, and as Rainer has mentioned, my connections to this place and to Frankfurt go back so far. Well, maybe not so far, but let's put it this way, on the other side of 30 years. And in this crazy world where so much is so fragmented and disunited, and we live with so much breaks in temporality and space, it's so wonderful to be able to come back to a city not only that I love and that I know well, but also to have the sense of intellectual continuity. And when I look at the room today, I feel like I'm in my seminar. Yeah. Okay. Delving into a new topic. This is a foray into legal philosophy, jurisprudence. I have been nibbling at the ends, on the edges of some of these issues, and this is truly new work, and I very much look forward to the conversation that we will be having this evening, and I have this. Okay. Immanuel Kant begins his famous 1795 essay Zum ewigen Frieden, ein philosophischer Entwurf, concluded at the end of the revolutionary wars between France and Prussia with a well-known joke. I will read this in German. Kant writes, ob diese satirische Überschrift, worauf ein Kirchhof gemalt war, die Menschen überhaupt oder besonders die Staatsoberhäupter, die des Krieges nie satt werden können oder wohl gar nur die Philosophen, gelte, die jenen süßen Traum träumen, mag dahingestellt sein. End of quote. Whether it is humanity at large, or leaders of states, or maybe even philosophers, who dream the sweet dream of eternal or perpetual peace, a phrase painted by a Dutch innkeeper on the picture of a burial ground is Mut, says Kant, dahingestellt. The point is that one can enjoy the sweet dream of perpetual peace not in life, but only in death. And this is the meaning of the joke, zum ewigen Frieden, eternal peace. Of course, Kant himself proceeds to propose preliminary and definitive articles of peace among states. And he is aware, well, of the irony that accompanies his philosophical proposal, his Entwurf. But this does not deter him from trying to make perpetual peace among nations possible. Surely, I'm not the only one among you who has thought of Kant's joke in view of the second, actually, significant land war on the European continent since 1945. We forget the Yugoslav civil wars that lasted a decade, roughly from 1992 to 2001. The Russian aggression towards Ukraine and its people has raised hard questions, yet again, about the status of international law, and in particular about the status of the United Nations Charter, which outlaws war except in cases of self-defense. Chapter 7, Article 51 reads, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security," end of quote. The Security Council resolution of February 25, 2022, held Russia accountable for violating Ukrainian sovereignty, international law, and the UN Charter. But since Russia is a permanent member of the Security Council, it vetoed the resolution. Perhaps more dismaying than Russia's veto is the fact that the UN General Assembly vote condemning Russia's invasion of Ukraine and calling for withdrawal resulted in 141 votes for, 35 abstentions, and 5 votes against. The countries supporting Russia were predictably Belarus, North Korea, Eritrea, and Syria. Abstaining were not only China, Cuba, and Nicaragua, but many countries of the global south, such as Congo, El Salvador, Mali, Mozambique, Pakistan, Senegal, South Africa, Uganda, Vietnam, and Zimbabwe as well. Countries whom one would have thought to be sympathetic to the plight of a smaller country being attacked by a superpower. Now, in the meantime, we have found out about the agricultural dependence of some of these countries on trade with Russia, and also Russia has been very active in South Africa supporting anti-apartheid movements for many, many years, so this vote is complicated. But there was a common argument about the hypocrisy of the big powers in using the United Nations and international law to their own ends, condemning certain invasions and violations of sovereignty, while condoning others, such as the invasion of Afghanistan and Iraq, for example. Volumes have been written about the current dysfunctional setup of the Security Council, which privileges the 5 permanent members who have veto power, thus making it impossible to reform the UN Charter, such as to accommodate the criticisms as well as aspirations of many countries from the global south, and certainly not only those. Their vote in abstaining expresses their profound distrust and lack of faith in the universalist premises of the Universal Declaration of Human Rights and the institutions of international law. The World Society of States, far from displaying a normative order, seems to be in a condition of perpetual normative disorder. In this lecture, my concern is not with the normative disorder of the World Society of States, but rather with the consequences of the current crisis of international law for the 1951 Convention concerning the status of refugees, which we will be discussing in the next few days. This document, the 1951 Convention and its 67 Protocol, are crucial to the post-World War II regime of human rights treaties and international law. I will argue at the end that the Ukraine war is heralding a significant departure from this regime towards a primordialization of territory and the ethnicization of refugee rights. Russia's aggression against Ukraine in the name of a Ruski Mir, a Russian world, may be the first manifestation of a new conception that threatens to replace the universalist human rights regime with a vision of spheres of ethnic influence, a version of Grossraum principles with which we are so familiar from Carl Schmitt's work, and we know that Putin himself has participated in seminars with Alexander Dugin, a Russian philosopher, putting forward a strange mixture of Hegel and Carl Schmitt. The consequences of these developments for human rights are disastrous, and their impact on refugee rights are regressive. The refugee once more becomes dependent upon the sovereign will of the receiving state and the goodwill and generosity of its neighbors. We are moving from the rights of refugees to the hospitality of close communities of ethnic kinship. I want to place these claims, however, in the context of some broader reflections about international law. So I shall begin taking my lead from Marty Kospaniemi to say something about the charge of hypocrisy that is often leveled against international law, but which has something about the deep structure of normativity and facticity in international law itself. In the second part of my lecture, I'm going to discuss Ronald Dworkin's posthumously published essay, A New Philosophy for International Law. Dworkin's essay revives Kantian principles, but his attempt to base international law on the rules of salience does not succeed, I will argue. We need a more inclusive universalism along democratic iterations, I've argued for in various works, and push Dworkin's considerations towards a more cosmopolitan direction. And in conclusion, I will come back to the 1951 Refugee Convention and contemporary developments in refugee regimes. Now, let me say something about the way I use PowerPoint. I have a text. The PowerPoint is just to accompany you for the purposes of reference and understanding. I'm not speaking from the PowerPoint, okay? So, in his well-known work, From Apology to Utopia, The Structure of International Legal Argument, 1989, and reissued in 2005, Marty Kospaniemi provides a deeper explanation for the charge of hypocrisy or inconsistency that is often leveled against international law. He writes, I don't know if I have, yeah. To prevent international law from losing its independence vis-a-vis international politics, the legal mind fights a battle on two fronts. On the one hand, it attempts to ensure the normativity of the law by creating distance between it and state behavior, will, and interest. On the other hand, it attempts to ensure the law's concreteness by distinguishing it from a natural morality that just would happen to be there. A law which would lack distance from state behavior, will, or interest would simply amount to an apology and lose its normative power. A law which would be wholly unrelated to states' interests or will would be utopian. International law must be both normative and concrete. It must be shown that it binds a state, regardless of the state's behavior, will, or interest, but that its content can nevertheless be verified by reference to actual state behavior, will, or interest. Now, this tension between normativity and concreteness, the distance between what the law says and actual behavior, or if you wish, between normativity and facticity, can often give the appearance of inconsistency. Since states' interests and goals evolve, the normativity of the law is put to the justification of a changing reality, thus creating exceptions to the rule, which are adjusted in the light of new constellations of power and interest. So why Afghanistan and why not Ukraine, etc. But why should international law be distinct in this respect from all other types of law? If all law, as a general rule, must deal with a concrete case and changing facts and circumstances, isn't this what law is? Aren't interpretation and adjudication necessarily indeterminate? Kospaniemi himself sees the indeterminacy of international law to be peculiarly intrinsic to this domain and distinguishes between two logics of argument. There are ascending arguments premised on the assumption that state behavior, will, and interest determine the meaning of the law. And there are descending arguments, by contrast, that refer to justice among nations, international community, and the like, which are supposed to be anterior or superior to states' interests and can override individual state behavior. Now, whereas arguments from apology are ascending, arguments from utopia, placing state behavior in the context of more general assumptions about peace, world order, and so on, are descending. Thus, according to Kosciuszko, international law is caught between apology and utopia, and fails in its quest for an objective character. Now, I'm using this introduction with Kosciuszko, which surely requires a lot of elaboration, but it helped me think through some of the question about the issue of hypocrisy that is always there in international law. It seems to me much more so than in many other domains of law. And I find this interplay between normativity and concreteness, between utopia and apology, really, really interesting. So I know this section requires more elaboration, but I will make a quick transition here. Whereas for Kosciuszko, international law is in a state of perpetual crisis, it seems, vacillating between the irreconcilable logics of apology and utopia. For Ronald Dworkin, the crisis of international law rests in the first place with defunct logical positivist assumptions. Dworkin presents an unapologetically utopian case for international law. I don't think it's even a realist utopia in the Rawlsian sense, but we can discuss that. Thus, Dworkin chooses one of the two horns of the dilemma outlined by Kosciuszko. Now, this essay, which appeared, posthumously, has not been discussed that extensively, but I hope I will arouse your interest in it with this lecture as well. Dworkin's A New Philosophy for International Law was published in 2013. Dworkin begins by noting that the status of international law has changed since his student days, when the question, is it even law, was paramount. He observes that with the discrediting of legal positivism in the mode of John Austin, according to which law is the command, quote, of an uncommanded commander, a more sophisticated account of international law emerged via H.L.A. Hart's theory. According to Hart, law exists when the bulk of the officials of a political community have come to accept as rules they have an obligation to follow two kinds of rules. This is well known in the philosophy of law. Secondary rules, which stipulate how law is created and enforced and identified, and primary rules, which are created and identified when those secondary rules are followed and approved. On this account, what the law of a community is depends on nothing more than contingent aspects of its social and political institutions and history. Hart's theory, according to Dworkin, eliminates the gap between facticity and normativity, between utopia and apology altogether, making law simply an aspect of states' behavior in following certain rules. For Hart, then, the question as to whether there is international law amounts to whether there was, quote, any system or practices that can sensibly and usefully be described as international law. But Dworkin objects. I don't have a slide on that, so just let me go back for a second without confusing you. But Dworkin objects, here it is. Interpretive doctrinal questions such as whether the Kosovo intervention was legal under international law cannot be answered by considering whether it would be useful to speak of an international law that was followed in this case. Such doctrinal questions, argues Dworkin, require normative answers and not sociological analyses. Dworkin characterizes the dominant view among contemporary international lawyers as a form of neo-Hartian positivism. It is assumed that, quote, a sovereign state is subject to international law, but on the standard account only insofar as it has consented to be bound by that law, and they take the principle of consent to furnish an international rule of recognition. Now, Dworkin says, take what would be the equivalent of such an international rule of recognition. Article 38, paragraph 1 of the Statute of the International Criminal Court is considered to be such an international rule of recognition. The court has to resolve disputes in accordance with the international law, but it may apply international conventions recognized by the contesting parties, international custom as evidence of a general practice, the general principles of law recognized by civilized nations, subject to the provision of Article 59, and the judicial decisions of the most highly qualified practitioners of various nations. Now, additionally, international lawyers speak of so-called norms of jus cogens, which political philosophers have paid some attention to. Jus cogens against genocide, slavery, ethnic cleansing, and of course, when you say etc., this is the point of the matter. There are different interpretations as to what this etc. in jus cogens involves. Is non-refoulement, for example, which is a primary principle of the 51 Refugee Convention, is a jus cogens norm. That is to say, is the obligation not to deny the right of a person to seek asylum who has a credible fear of persecution and serious harm in the hands of authorities of individuals when returned to the territory from which he or she originates? Is this a jus cogens norm or only binding for those states that have signed the 1951 convention? There is still considerable disagreement about this issue among international lawyers, and this is where Dworkin's critique begins. By the way, is it possible to open a window or something? Now, Dworkin rejects state consent argument in several steps, only some of which I will summarize here. First, he argues that such an account offers no priority among the different sources it recognizes. And this is getting into the weeds a little bit. Do treaties take priority over customary practices, for example? Second, such an account sometimes seems to bind those who have not consented to it as well. Not all members of the United Nations have signed on to all the general treaties, human rights treaties, which have been accepted by the General Assembly. To give you an example, India and Myanmar themselves are not members of the 1951 Convention. But are we ready, what are we going to say about the status of refugees in this country? So what are we talking about with consent? Are these articles binding on non-signatories as well? Third, how many states must accept practices as legally required before we can consider it customary? Customary, such as, so if you know that this is a well-known objection. Now, I will argue later in this lecture that there is a more dialectical and a more iterative way in which to understand the principle of state consent, particularly with respect to major human rights treaties. But Dworkin's central objection to the principle of consent is that without engaging in doctrinal interpretation, it is impossible to figure out what it is that consenting nations are consenting to. And I think I agree with this point. Dworkin provides a particularly compelling example of this problem that resonates in the context of our current concerns. Again, let us take Article 2, Paragraph 4 of the United Nations Charter, which provides that, quote, all members shall refrain in international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other matter inconsistent with the purposes of the United Nations. Dworkin asks, how should we understand territorial integrity or political independence? Do humanitarian interventions undertaken by NATO in Kosovo or Libya with the aim to stop genocide or crimes against humanity violate territorial integrity or political independence? It's obvious that they do. It's also obvious that not all member states would share answers to these questions, just as the 35 states which abstained from the vote condemning Russian aggression did not agree with the majority interpretation of what international law required. Dworkin then draws the conclusion that we cannot take the self-limiting consent of sovereign nations to be the basic ground of international law, though the temptation to do so is understandable, end of quote. Now, here come now the meat of the argument. This may have been a little too technical for those of you who are not doing international law or legal law, but in the rest of this essay now, Dworkin develops his well-known interpretive concept of law and applies it to international law. Interpretive, sometimes referred to as interpretative, political concepts are normative. They are based on a theory of political morality about the circumstance in which something ought or ought not to happen. How far can an international jurisprudence be constructed on this basis? How far can we treat international law as a part, but a very distinctive part of what morality and decency require of states and other international bodies in the treatment of one another, asked Dworkin. He's not getting to the heart of his real argument. Dworkin states that the first interpretive principle of a new philosophy for international law is what he refers to sometimes as duty, sometimes as responsibility of mitigation. I'm not going to focus on this distinction, but here is what the principle of mitigation is. If a state can help facilitate an international order in a way that would improve the legitimacy of its own coercive government, then it has a political obligation to do what it can in that direction. The political legitimacy of a state vis-à-vis its own citizens requires it to prevent its own possible future degradation into tyranny. I find that an astonishing sentence. States have a general obligation to improve their own political legitimacy by improving the overall legitimacy of the international order in which they are embedded. Note now how seamlessly Dworkin draws together principles of domestic and international political morality. International law is not only about maintaining the integrity or self-interest of territorially distinctive units, each competing, jostling, and warring with each other. International law is about improving and augmenting the political legitimacy of the state system as a whole by ensuring that coercive government would never violate the basic rights of its own citizens. In Kantian language, Dworkin's argument seeks to establish that a republican form of government based on respect for the dignity of those subjects to its laws and a cosmopolitan international order in which states forsake the right to aggressive war minimally in their dealings with one another, that they are mutually interdependent. And this was Kant saying in Zum ewigen Frieden. He writes, Dworkin, people around the world believe that they have, and they do have, a moral responsibility to help to protect people in other nations from war crimes, genocide, and other violations of human rights. Their government falls short of its duty to help them acquit their moral responsibilities when it exceeds the definitions of sovereignty that prevent it from intervening to prevent such crimes or ameliorate their disastrous effects. Together, these duties call for a more complex regime of intervention in the affairs of individual states than that system provides. End of quote. Now, Dworkin was struggling with these questions during the time of, as he writes, the Kosovo and Libya interventions and so on. And the essay is really just going back and forth about this. And you can see that he provides an extraordinarily abstract justification for the practice of humanitarian interventions and the doctrine of R2P, responsibility to protect. There is one further step in this essay which I have to mention before proceeding to a critical consideration of Dworkin's contribution. The duty of mitigation, Dworkin says, forms the most general principle for an interpretive conception of international law. But it's not sufficient, precisely because any of a number of different systems of international law could satisfy it, although Dworkin does not mention what these examples would be. Instead, he introduces, I think, and makes a strange concession to the facticity of state consent with the principle of salience. Yeah? Now, this is grammatically very complicated, maybe because it's not conceptually as clear as one would like. If a significant number of states encompassing a significant population has developed an agreed code of practice either by treaty or by other form of coordination, then other states have at least a prima facie duty to subscribe to that practice as well, with the important proviso that this duty holds only if a more general practice to that effect, expanded in that way, would improve the legitimacy of the subscribing state and the international order as a whole. So take a deep breath and reread this. Okay, this is the principle of salience. At first blush, the principle of salience seems to reintroduce the centrality of state consent through the back door. Dworkin is aware of this problem and argues that, for example, the Charter of and the institutions of the United Nations are best understood, quote, not as arrangements binding only through contract, but by the moral force of salience as a route to a satisfactory international order. The core of his argument rests with the proviso that subscribing to the principle of salience, quote, would improve the legitimacy of the subscribing state and international order as a whole. And what are examples for Dworkin of principles of salience following from principles of mitigation? The UN Charter, the Geneva Conventions, which also include the 51 Refugee Convention, but as you know, they are the humanitarian laws about treatment of prisoners of war, etc. The Genocide Agreement and the Treaty of Rome establishing the International Criminal Court. These are of this nature, and that is, they have universal validity because they are based on the principle of salience and are not just based on consent. And he distinguishes rather sharply these treaties and laws from the agreement creating the European Union and the WTO, which he seems to think are more like clubs. Okay. We may call Dworkin's new philosophy for international law a normative reconstruction of the principles which would legitimate the post-World War II system of the UN and human rights-based international law. Such a normative reconstruction is demanding, and for some it may even be too obtruse. One of its chief weaknesses is that it is a teleological as opposed to a deontological account, in that it imposes upon judges as well as other decision makers the obligation to judge whether certain practices and forms of state behavior can be said to contribute to the legitimacy of the state system as a whole. This is a tall order. And for the practitioner, the beauty of Hart's conception of secondary and primary rules is that it provides them with a clearer and more predictable decision procedure than Dworkin's proviso. Now, Dworkin could answer, and he does, that his philosophy for international law addresses the justification of the system as a whole, and he insists that in the event of hard cases, even practitioners who need to fill in the gaps which the law does not address might turn to his principles of mitigation and salience. I will skip the next section. There is considerable discussion among international jurists and theorists like Samantha Besson, Thomas Cristiano, Bashar Chali, and others as to whether Dworkin's interpretive philosophy of international law defends a form of cosmopolitanism or remains statist. Cristiano argues that it is not really cosmopolitan, but must be pushed more in that direction. And Samantha Besson thinks that actually it is good what Dworkin does because he eliminates the dichotomy of statism and cosmopolitanism by placing state legitimacy within the legitimacy of the international order as a whole. But I want to come now to some questions which will be more pertinent and relevant for our own workshop. The hard questions in Dworkin's new philosophy of international law concern, and there are quite a few, to return to Koskoniemi for a second, whether such a system can deliver any form of concrete normativity that would be binding on state behavior. Or has the facticity of international law, its doctrine and history, been dissolved all too readily into a Kantian moral philosophy, which we all love, but which we have to raise this question. And by facticity here, I do not mean just the coercive power of law, but the history of its interpretation, adjudication, and application. We need a less a prioristic route to mediate the normative and the factual and balance apology and utopia. The concept of democratic iterations I've developed in several works in recent years was an attempt at such a mediation of normativity and facticity. And I want to just illustrate this claim with respect to the way in which state consent functions in major human rights treaties. As is well known, state consent, no matter how indeterminate its content, and all consent is open to interpretation and iteration, is constitutive for any treaty ratification process. There are, of course, different institutional models as to how this can be achieved, whereas in some polities named the monistic systems, international law becomes part of municipal law. In other polities named dualistic, special institutional ratification processes are required. The United States, which requires 2/3 of Senate ratification to approve a treaty before the president can ratify it, poses one of the most difficult procedural hurdles. And we all know that although the United States was a high party to the Genocide Convention, it didn't pass the US Senate until about 1982. Now, regardless of what institutional access mechanisms are followed in the event of a ratification of a major human rights treaty, states have the prerogative of placing RUDs, reservations, understandings, and derogations on such a treaty. Following the insight of my colleague Judith Resnick's at Yale, whose work has greatly influenced me, I'd like to view the process by which states develop as well as change the RUDs as a dialogic or an iterative process, and not just like a simple act in time, which it isn't. State consent is active here insofar as those who have the right to speak in the name of the state must formulate reasons why they are taking exceptions to this or that article in major human rights treaty. There is always some conversation going on between the treaty body interpretations and state bodies. For example, it is well known that although most Islamic states accede to treaties such as CEDAW and the rights of the child, they place Islamic law, the Sharia, and the sayings of the Prophet as the primary source of law and not the authority of the UN treaty bodies. Nonetheless, whatever the ultimate source of normativity of the law is considered to be by these countries, Sharia or the Hadith, once treaty accession and ratification takes place, civil society organizations and human rights groups begin to engage in an iterative process in which a contentious dialogue can take place between defenders of existing local practices and those who call for conformity to international rights defended by these treaties themselves. For example, and it is important for social movements, in the case of custody rights over a child, which would automatically go to the father, Muslim women's lawyers have been able to advocate in Islamic courts on behalf of the rights of the child by arguing that custody must be shared among the two parents. Such processes set into motion a novel interpretive understanding of what the local law may involve. Would it be compatible with the wisdom of the Prophet not to want what is in the best interest of the child? And how do we adjudicate this? You can see that there is rhetorical power here, saying the best interest of the child should not contradict the wisdom of the Prophet, right? Now, I'm aware that there is a large body of empirical literature among international lawyers, like my colleague Una Hathaway at Yale, that is skeptical whether treaty ratification yields treaty compliance by states. But my point is a different one. I'm arguing that the public formulations of a human rights treaty to which a state has, oops, what happened to I don't have that, sorry. Let's go back. Let me repeat this. My point is a different one. I'm arguing that the public formulations of a human rights treaty to which a state has acceded, even if with drugs, makes available a language of public justification to social actors who can then face the coercive power of their own polities and talk back to power in the name of rights. This is not inconsistent with Dworkin's general view that international law is justifiable in the final analysis because it augments the legitimacy of the coercive exercise of power in the state system as a whole. But I am arguing that such augmentation or enhancement of a state's legitimation must take place through the participation of civil society groups as well as social movements in developing interpretive vocabularies by appropriating the language of rights. Even if such groups are not the originators of these treaties, which require the specialized and long work of legal bodies and other associations, state consent, insofar it is fair and representative, can enable democratic participation and iteration by mobilizing social movements and groups that sometimes speak back to the treaties themselves. And there is some really interesting stuff going on in this process of dialogue or conversation. I mean, I think that, again, one of the most interesting examples comes to us from Tunisia, in which an Islamist party, Ennahda, nonetheless was able to reformulate with the help of women's groups for the first time an equality law, a law granting equal rights to women and men in standing. So just like these iterative processes are happening. So such processes bring together normativity and facticity, or in Koskonyi's language, they narrow the gap between utopia and apology by bending states' apologies towards a utopian horizon. If the principle of salience is not to be treated as a sheer factum brutum, describing existing practices upon which some states happen to agree, we must analyze more closely how the proviso of the legitimacy of international law can become an aspect of the self-understanding of the citizens and residents of equality. Okay, I'm coming, I do need another 10 minutes, you have to bear with me. Okay, one more critique of Dworkin before I return to the 51 Convention. Recall once more this complex principle of salience. Okay, I'll just let you read it while I'm grabbing some water. We must not only ask who the significant number of states encompassing a significant population involves, but we must also question whether, in proceeding from a hypothetical sovereign equality among the parties to this code or practice, Dworkin's philosophy neglects relations of power, inequality, and exploitation among states to such an extent that significant omissions and distortions can result in the final practice. This objection has been raised most forcefully in recent years and in various contexts by a group of scholars that name themselves TWAIL, Third World Approaches to International Law. Beginning with the pioneering work of Anthony Angie, Imperialism, Sovereignty, and the Making of International Law, TWAIL scholars have made us aware of doctrines, practices, judgments of international law, which perpetuate the inequality among states at the very origins of the post-World War II system of international law and institutions. Angie focuses on the concept of sovereignty and analyzes in great detail with respect to the concept of dependent sovereignties formulated at the end of World War I, how the mandate system over previously colonial possessions gave rise to subsequent implications in international law. And here's the quote: "The mandate system, by adopting the concept of trusteeship, justified the management of colonized people by presenting it as directed by concern for native interests and a desire to promote self-government rather than by the selfish desires of the colonial power." Angie shows that even after the era of decolonization, when former colonies attained their independence, conceptions of sovereignty in international law permitted the control over the use of natural resources in colonized countries by their former colonial powers. This is one example among many others that he analyzes in the book. Other scholars, former students such as Adam Getachau, have shown how attempts among the Caribbean nations to form new economic unions in the form of federations were defeated by global capitalism. Okay, and it's a very nice book, World Making. Getting tagged. World Making After Empire: The Rise and Fall of Self-Determination. Sorry. And Tendai Achiume, whom we have invited to participate, but who cannot be here, but maybe will be part of our volume, has analyzed how a concept of exclusive sovereignty, still at the center of the 51 Refugee Convention, has to take into account the history of colonialism and move towards maybe a concept of co-sovereignties. Okay? Now, these criticisms and contributions are usually identified with an anti-universalist trend in normative theorizing in favor of a focus on technologies of power. Angie makes this Foucauldian approach his own, but as you know, the risk in these valuable contributions, from my point of view, is that they may reduce international law to mere apology. i.e. to a mere instrument for the justification of state interests and power. They don't avoid this. They cannot avoid this error. This would be a mistake because the task of an internal critique is not to debunk, but to reconstruct the normative kernel in such a way as to let it reveal the unrealized but perhaps realizable utopian premises. Dworkin's interpretive philosophy as a whole is a contribution to such a reconstruction of the unrealized normative kernel of international law. So, back to the Refugee Convention. All these considerations in the philosophy of international law may seem rather removed from the concerns of the doctrine and practice of refugee law. Yet, I'm hoping this is not so. Just as the philosophy of international law has to give up its continuing sovereigntist focus by paying attention to the condition of refugees and migrants and others, refugee law can benefit from more theoretization of its own strength as well as limitations. From the standpoint of Dworkin's philosophy of international law, the very existence of the refugee is an indication of the failure of the principles of mitigation as well as the inadequacies of the current principles of salience. Okay? The existence of the refugee at the simplest indicates that the legitimizing grounds of the state's exercise of coercive power over its own citizens, residents, and others has been violated. And the system of salience that has been established to protect refugee rights in the post-World War II period is itself under serious strain, both institutionally and doctrinally, and not to say that maybe it has become dysfunctional. In the next few days, as refugee scholars, political philosophers, and international lawyers, we will be discussing the following questions. Is the distinction between the refugee and the migrant still viable? Do obligations toward refugees value only those states that have acceded to the convention? Are the 5 named grounds of persecution, namely race, religion, nationality, membership of a particular social group or political opinion, adequate to deal with the causes of today's refugee and migratory movements? Is the distinction between convention refugees and those seeking humanitarian relief for reasons, for other reasons like reasons of climate, defensible and viable? How can we incorporate climate into the 51 Convention? An overarching concern of our workshop is the reconceptualization of borders, territory, and territoriality. Dworkin's work, despite cosmopolitan premises, leaves the matter of territoriality wholly covered by the shield of sovereignty. This is why in his work, as in Rawls's, John Rawls's, territoriality remains a historically contingent and uninteresting fact. But individuals are entitled to rights and protection insofar as a certain jurisdiction bears certain responsibilities for the territories they are located in. And as Ayelet Shachar has shown in her book, The Shifting Border, the contemporary state system is reinventing the border, which no longer is viewed as a static wall or a barrier, but is a mobile system of control that seems to move as the refugee and the migrant themselves would. Of course, I don't want to neglect that territoriality should not lead us forget that historically, as well as in the contemporary world, oceans and the seas have played a crucial role as passages for refuge and migration, as Itamar Mann's influential work has shown. Final thoughts, really final. But there's a new challenge on the political horizon, which threatens to change the post-World War II system of territoriality altogether. Without getting lost in the noise and confusion of everyday politics to Sturm and Drang, I want to note again that Russia's invasion of Ukraine did not even engage in the usual practice of state apology. I'm referring to the February 22nd, to February 12, 2020. speech by 2022 speech by President Putin, no principle of self-defense or some other threat posed by Ukraine to Russia was invoked. Instead, Mr. Putin stipulated a primordial and mythic unity of the Russian and Ukrainian peoples in the name of the Russian world, Ruski Mir. Ukrainian territory was said to be an integral and indivisible part of this Großraum, in a clear contradiction with the expressed will and aspiration of the Ukrainian people themselves since 2004 at least. I'm not interested here in questions of German Ostpolitik, whether Putin's reactions were caused by American imperialism or his own megalomania, his twisted psyche, nor am I really saying things here about arms, intervention and so on. Reasonable people can disagree about matters of war and peace. What interests me is to point out simply that a concept of territoriality in terms of primordialist claims based on some mythic history has emerged in the continent of Europe. Such primordialist claims are not altogether new. The Zionist settlement in Palestine is probably the most prominent example, but such primordialist claims are found throughout the 19th century in the many aspirations of nationalist as well as separatist movements as well. But such primordialism brings a shift from the vocabulary of human rights and international law to a language of ethnic kinship and solidarity. The shameful discrepancy in the treatment of Afghani, Iraqi, and other refugees caught in the border between Belarus and Poland this winter, when contrasted with the warm reception of fleeing Ukrainians, has often been pointed to. And we have a very interesting paper by Catherine Costello in the workshop reflecting on the question of discrimination. And I want to say something very clearly. Ukrainian refugees deserve and are entitled to the best treatment and hospitality they are getting. But so were Afghani and Iraqi refugees entitled at least to an asylum intake interview, at least to that, and not to be thrown, not to be just dispelled like wild animals in the forest. The Polish government violated the 1951 convention in not doing so. So that's my point. Precisely because I fear that such primordialist and ethnicistic claims will be juxtaposed to the language of universal human rights, and precisely because the post-World War II human rights system is facing maybe one of its worst legitimation crises, I found it sobering as well as enlightening to focus on some of the fundamentals of this international legal system by going back to one of the founders of liberal internationalism. Ronald Dworkin's insistence that states must justify coercive exercise of power over their citizens and residents by respecting the equal worth and dignity of each individual is fundamental to this post-World War II world. And his attempt to ground the system of international law, which is so often beset by fragmentation, non-compliance, and exceptionalism, in the light of states' obligations to enhance their own legitimacy by enhancing the legitimacy of the system as a whole through compliance with the principles of mitigation and salience, cut through the sound and the fury of the present by reminding us of our normative essentials and fundamentals, something we definitely need today. Our task is to push this framework even further towards a progressive cosmopolitanism by confronting it with a new reconfiguration of rights and territoriality and borders such that all persons, and not only citizens, are considered beings of equal moral worth and dignity in the world community. Thank you all for listening.
so we have about, let me just check the time here. We have about almost 25 to 30 minutes for the Q&A session. So I'll keep the queue here. And maybe you want some water just to catch up? Okay, good. All right, perfect. So we are open to Q&A if anyone wants to begin. All right, wonderful. So over there, please.
Hannah. Thank you so much. This was a fabulous talk. So my question, I don't think this is on either. Hello? Okay. Okay, so my question is about how to bring another set of peoples into this discussion that also are dealing with the problem of homelessness in contemporary societies, and that's Indigenous peoples. So in the talk, you give a very strong critique of primordializing claims to land. And I happen to agree with that. But how then do we deal with Indigenous claims to land that rely on primordial attachment to the soil? So, I live in a settler colonial society. I live in Vancouver, British Columbia. And in Indigenous scholarship and in simply mainstream politics, there's a lot of references to we've lived here from time immemorial. There's a famous book by Liam Simpson, an Indigenous scholar, called As We Have Always Done. And so I'm wondering, how do we square the problems of exclusion? So there are, migrants and refugees are dealing with homelessness as a problem of exclusion. But can we square those politics of homelessness, let's call it, with people who are facing the theft of land? So the primary problem for Indigenous peoples is land theft, not exclusion. And in fact, Indigenous people are very wary of critical theory discourses that are focused on inclusion, because those spring from discourses around migration. And for them, the real problem is land theft. And yet, migrants and Indigenous people both face the key problem is homelessness, having a place in the world. So how do we normatively reconstruct an international law that doesn't oppose these two groups? And I want to give an example of a political movement I learned about from one of my students that made me think, well, maybe these groups are not facing conflicting problems. There was a political movement in Quebec, I believe, where there were Indigenous people fighting for migrant rights, and their slogan was, "No one is illegal on stolen land." And I thought that was very interesting. But I'd love to hear your thoughts on it. Thank you so much.
Thank you, Anna. There was a very interesting and lively session last week also with Melissa and others. I think two replies to this. I thought about how difficult this concept is, might think. It's a matter of equality and power and history. Right? When those who are claiming primordial attachments are those who have been in a condition of being exploited, driven from their land when their habitation is being questioned, or you're dealing with power relations, and there the concept of primordiality alone as an ontological concept is not going to get you that far. You have to bring in question claims of equality, and in the second place, I would say you have to bring in questions of historical redress. Now, this has interesting connotations when thought about with respect to the current situation, because there is a claim that somehow the monastery in Kiev, and there may be people here who are Orthodox Christians now who notice that there is the claim, even Putin made this claim, that the monastery in Kiev is the origin of Russian Orthodoxy. And therefore, the monastery in Kiev shows that the Ukraine was, always part of Russia, right? But this is a primordialism that stamples upon historical redress. Because what the people of the Ukraine will tell you is that they have been trying to write their own narrative, their own history for the last God knows how many centuries. And so in that case, you can't just you can't just disregard the current will of the people in the name. I mean, these get all very complicated, right? I mean, I'm not going to talk about Jerusalem. Ayelet can help me parse this out. But thank you. Great question there. I think primordialism has to be placed in the context of power and equality and historical memory.
Ah, wonderful. I believe that Klaus Günther is next.
Yeah, thank you. Two questions concerning the RUDs. There is an interesting story when Germany entered the European Convention of Human Rights. It made an exception that the article in the convention which made an exception of the prohibition of retroactive punishment concerning crimes against humanity, Germany made an exception, of course, with regard to its own past. They wanted to uphold the principle of prohibition of retroactive punishment, and nobody really knew. And it was abolished, I think, in the early 90s after German unification. And my question is, doesn't this principle which you claim in the ratification process of the treaty presuppose a civil society which is prepared to scandalize such exceptions? And if the civil society does not, it does not work, then the state makes an exception and everybody agrees, and there is no scandalization in civil society. The other question is more general. It concerns hypocrisy and abuse of law. The problem of hypocrisy, at least of the Western legal tradition, is, you already mentioned it, they claimed to realize human rights, and in fact they did something else. They contradicted, they instrumentalized human rights in order to, in a brief sketch, to establish an order of repression to colonized countries. And I think that what many autocrats today do, they copy this kind of hypocrisy, because most autocrats talk the language of legalism. They use the language of law, and they do the same. They instrumentalize the law in order to realize illegal purposes. And my question is whether your approach and perhaps also Dworkin's approach presupposes something like a principle of sincerity in applying international law. And whether how one could, if this is true, how one could reconstruct such a principle of sincerity. Because I think that the Hartian model, and I think Dworkin is right, the Hartian alternative, it allows for instrumentalization, just as a matter of fact, who has is empowered by secondary rules and so on, and you can instrumentalize that for different purposes. But I think Dworkin's, your approach presupposes a kind of sincerity in applying the law and dealing with international law. And I would like to know whether you agree and how one could reconstruct this principle of sincerity.
Thank you, Klaus. First, thank you for letting me use your office while you were away with me. I very much appreciated it. I felt very at home with all the books. I must say that the first example seems to be more of a confirmation rather than an objection, and I didn't know this. So thank you for this example. I think I have to look into it because it does seem like a civil society mobilization, and that would be worth looking into. The second question is really very, very, very interesting and important, and really, I mean, we know now that, you know, rule of law and rule by law, right? I mean, rule by law regimes, all autocratic regimes, from Hungary to Poland to Turkey, Brazil, maybe, that, you know, there is a difference between rule by law and the rule of law. So these regimes are not totally, you know, hors de loi. But look at the case of Turkey, for example, about which I know something. They have been the last 6 years. You know, Turkey has been governed by something called kanun hakkında karar. That means that verdicts in the place of law. Kauka. You know, this is just simply a stipulation since the state of emergency. The state of emergency has not been lifted. So this is a very good example. So you say, does one need a principle of sincerity? I think that what one needs, and I do believe that Dworkin tries to fill this in, one needs a principle of democracy. You have to bring together the rule of law and the principle of democracy. And I, you know, you calling it sincerity is, I think it's good, but it's not sufficient. It's not going to get you from out of the problem of what Judith Clark called legalism, right? I mean, rule by law is a form of legalism, not legality, legitimacy. It is legalism, but not legitimacy. So how you can build this in? Would you build it in the Dworkinian system, or would you try to do it, you know, with my own categories? But I take your point that this is essential for the principles of mitigation and salience to go farther than they do. Thank you.
Yeah, I also like this question because it brings us actually, it's not only international law, constitutional law has been dealing with this, you know, this abuse of constitutionalism very prevalently. So this is it actually might be nice for the project to connect the two dimensions, and at least in that sense, perhaps it's the same set of concerns, but I'm not going to abuse my role here as a moderator. So I think the gentleman in the back, I think you had a question? Yeah, with the green shirt, yeah.
Is this on? Yeah, good.
Oh, yeah. Daryl, we didn't recognize
I know
we
that
couldn't recognize you with your mask.
Yeah.
Okay, good.
Yeah.
Daryl,
Who is that masked man? So Seyla, this was terrific. It was super interesting discussion on a very important topic. So thank you very much for that. I'm trying to understand the exact character, I guess it is, of your criticism of Dworkin, because it sounds important to me, but I don't feel like I quite have a handle on it. So when I read that principle of salience, I haven't read the Dworkin article before, so thanks also for alerting me to it. When I read that principle of salience, I'm struck by the sort of formal similarities to the first formulation of the categorical imperative. So the idea of the first formulation of the categorical imperative is that a maxim is justified. A maxim is justified to the extent it can be universalized, right? And that can be the subject of universal law or universal will. And it strikes me that the principle of salience is, well, there are these treaties or groups or conventions amongst groups which are legitimate or valid subject to the proviso, right? And the proviso is really a demanding proviso. The proviso is, if it were generalized, it would make all states, it would facilitate the legitimacy of all states. And one of the kind of dialogical responses to the categorical imperative is to say that it's not just a matter of universalizing the will, but we need to think about whether or not an action would be subject to verification or agreement under sort of idealized situations in which everybody spoke about it. That's a kind of dialogical reinterpretation of Kant. Are you suggesting a kind of dialogical reinterpretation of the Dworkian principle of salience, that there's something like a move towards a universalization, but that it has to be in some way dialogical? Is that the idea? Or is this just not a good framework for thinking about what you're saying?
It's a very good framework because it is originating in the same kind of philosophical impulse that I have followed. I think that since I started thinking, it's the same. The question is, how can you follow this dialogic principle in a very different and specialized context of international law? Most of my law colleagues think that, what is this? This is sociology. What are you doing? But how does this come in? But it can come in when you begin to think of, someone as forceful. Dworkin first, as I said, he has a very poor understanding of the function of state consent and treaty mobilize. The way in which these rights treaties mobilize civil society. There is a huge discussion about this, but I will subscribe to my point that if you take a dialogic model, what the dialogic model gives you is not just simply a dry, sort of document that specialists have to draw up. We can draw up these documents, right, in their complexity, but they set something into motion, and we have so many examples of this. That is, of social movements picking up some of the principles. Again, I think of the women's movement where this has been very active, but I think now also it's going to be similarly active, I believe, in the ecological movement, because there's just no way that some of these treaties and so on can anticipate all the input that is needed for this. And I think Michael, Doyle has worked on this exemplary mobility, International Mobility Convention, and the input that is required into something like this. We're not paying enough attention to it as theorists, maybe because it sounds too sociological, but to me, it is a manifestation of a profound philosophical point, which is the dialogical force of mobilized agents. Again, I'm going to give you another example from the force of this in the women's movement. CEDAW made it possible in countries like Turkey and Israel and Poland, where the honor of the family and the unity of the family is extremely significant, and women are reluctant to talk about abusive marriages, rape in marriage, because it affects the unity of the family. Now, once CEDAW was acceded to, what starts is also the opening of women's shelters, women's houses, where women who have been abused, who will not go to the police precisely because they exercise family solidarity, or because they don't trust the police. The police come and they don't do anything. This may not fit a pure. This is this is concretization. Philosophically, yes, you put the nail on the head, and that I've worked on discursive and communicative ethics. This is where I'm coming from. But it is of interest to me that these are not just empty ideals, as Reiner would say. Normativity is concrete, right? And so, this is my perspective as a critical theorist of seeing also the norms in action and what difference it makes. It may be. Let me add one more thing. The skepticism towards human rights norms today is not coming from the third world and third world activists or the global south, okay, which is a preferable concept. It's not coming from them. It's coming from intellectual cynics among ourselves. It's coming either from the revival of realism, and, you know, in a world that is at war, realism, you know, realists have to say, and we Kantians look like schmucks. You know, it's just like, who listens to us? We are dreamers, right? But the cynicism about universalism always comes from certain directions. It's either Nietzschean skepticism, it's either maybe a kind of, I don't want to name names, it's okay. We don't want to get into the battles of the 80s. It doesn't matter. But thank you for bringing the groundwork and cut back into the picture, yeah.
Yeah, I mentioned earlier on the junior generation, we had like really junior, you heard the babies were very interested. So very nice to know that you have such a, extended audience here. In terms of, I think we have time for one last question unless someone is really pressed to add a question, let me know. I'll turn in a minute to Michael Doyle. But it's interesting because a test case for you might be the new global compacts.
Yeah.
They're non-binding, right? So legally they're clearly non-binding. Would they actually have this kind of mobilization effect? Will they be aspirational and turn out to be very significant for that reason, despite the fact that clearly they are explicitly non-binding? That would be a nice test case to actually explore this. And of course they deal with refugees and migrants. So I think a very nice elucidation potentially of the argument that you're making here. So Michael, you get the last question.
Thank you. Can you hear me?
Yes.
Good. Thank you so much, Seyla. I found your analysis stimulating, wide-ranging, philosophic, sociological, all at the same time. So classic Seyla, and I really appreciated that. I also struggled with Dworkin's essay when it first came out. And in the end, I was just frustrated with it. And maybe different frustrations from yours, but I also sensed some of your frustrations. When I read through the essay, I saw this ideal of how an integrated legal order could be conceptualized through the process that he identifies of affiliation between deep principles and existing practices and making them coherent and generalizable over the long term. So I can be sympathetic to that, but what I thought was missing was the actual working of the international legal business, let's call it that, or the actual way in which law shapes and influences and doesn't shape and doesn't influence policy. And there we see a world that's radically more decentralized, where it doesn't fit that model. We see a world that's radically more fragmented, and most importantly, one that's really contested. And the way in which the law, as I've seen it, operates is as a language of contestation, struggling towards some degree of persuasion. So, for example, when the United States was attacked on 9/11, the original U.S. view, well, let's treat this as the Article 51 you put up on the board. We've been attacked, other states can come to our assistance, that's it. But then some other lawyers within the UN system pushed back and said, look, it wasn't really Afghanistan that attacked you, it was Al-Qaeda with some undetermined level of support from the Taliban, but they just promised to extradite them to Moscow. And so the pushback was that the world's more complicated. And why not take advantage of the ways in which the secondary rules that Hart talks about can provide specific legitimation for contested circumstances. Take it to the Security Council, which the U.S. was then persuaded to do, come out with a vote under Article 39, Chapter 7, determining this to be a breach of the peace and a continuing threat to the peace, which justifies action. So building upon 51, but pinning it down with 39, and through a process of contestation that then produced persuasion, which then produced something like a temporary legal order in response to 9/11. And none of that really appears in the Dworkin analysis. And when you push back against him and say, well, the law is really useful because it ignites domestic contestation, where social groups use it to claim rights, which they have to validate domestically through the political process, that gets at the way law works, and I didn't see that in his argument. So that's why I liked what you were saying, and I thought that his argument was even more problematic, because he was missing the way in which international law as a business plays out in contests back and forth among states and other groups.
Yeah. Thanks so much, Michael, for that point. Yes, we agree. I think that what is valuable in what Dworkin is trying to do is, there's a very subtle shift there, which would be totally objectionable to the realist, saying the primary subject of international law are states or peoples. What are you talking about? Because all of a sudden it seems as if he has almost shifted the terms by saying it is the justification of the exercise of force. It is the legitimacy of the exercise of force by states insofar as they are embedded in a justifiable international system, right? So there could be an argument there. I would of course side with Dworkin, but one has to also see what is being avoided or reformulated. I mean, that's why I think Besson, whom I've talked about her interpretation with Ayelet on various occasions, is very clever when she's saying he's trying to do both, because you cannot have equality in states unless you have international, interstate equality as well. So the question becomes again, what is the balance in a theory of international law, if that's your ambition? It's not really my ambition. Between normativity and facticity, between normativity and the empirics. There's no question about the fact that Dworkin's examples, the institutional empirics are not very strong, right? And that leaves something to be desired. I guess my dilemma is that I share enough of his normative premises that I keep trying to build in this sociological, the sociological aspect. I mean, another question that I thought was going to come from this audience, you're letting me get off the hook, maybe everybody's tired, it's a nice day, and the normative orders throws fantastic parties, etc., etc. And that is the question that I haven't yet resolved, which bears a little bit on this and on something that you're interested in, and this is the question of pluralism. I mean, he's presupposing a pretty homogeneous international law system. I mean, you can say, well, what he's talking about is the architecture that we have, since World War II, with all its warts and problems, the United Nations is what we have, etc. But it would be interesting to try to play roles and Dworkin, a roles view that proceeds from international law as a law of peoples versus, this more rarefied Kantian perspective that proceeds from the dignity and equality of the individual, not even peoples. We would have to do some work there. And so I'm glad you left me off the hook, because as I said, I'm starting this project, hopefully. So thanks.
Wonderful. So we're looking forward to the more elaborated in the book, of course, but thank you for sharing this with us. It's extremely rich, and I'm sure some people still have questions. So what we'll do, we're just, because of time, we have to actually officially close. So I want to, first of all, thank everyone who supported us technically, administratively, all of you who did all the hard work to get us here. Thank you so much. You know who you are. Reiner Forst, thank you again for having us here, and Normative Orders for the beautiful introduction. And of course, all of you people who belong to Normative Orders, Max Planck Law, faculty members, students, and of course, everyone who came for the conference. We are very, very grateful that you have been with us and that the rain held, and despite the fact that it's humid, we're still good. So we're very excited. We'll stay here for a few more minutes if people still have questions. Professor Benhabib will remain here. I'll be here. And then for the conference participants and the Heavies, we're going to go upstairs. So maybe someone could guide you up there if we are still here. So yeah, Eva and Lilith are here and they're going to help us. So thank you so much. And Rebecca, you're here just on time because I was going to thank you for everything that you have done to make the existence of my group here possible. Could not have been done without you. So thank you so much. And thank you, everyone. We're officially adjourned, but please stay here if you want to talk for a few more minutes. And thanks again, Shayla, for a wonderful presentation. All right. Bye-bye.